Good afternoon, everyone. This is Desran Gamboa, the second reporter from Group 12 of Title 13, Special Corporations. So I'll start my report in Section 114, the Religious Societies, and under this provision, it states that unless forbidden by incompetent authority, the Constitution, pertinent rules, regulations, or discipline of the religious denomination, any religious society may incorporate for the administration of its temporalities or for the management of its affairs, properties, and estate by filing with the Commission articles of incorporation verified by the affidavit of the presiding elder or other member of such religious society. So, registration is not mandatory, or the law does not require the religious societies to register as a corporation, but they may do so in order to acquire legal personality for the administration of their temporalities or for their properties. So these are the things or the rules to be considered if a religious society wants to register as a corporation. So letter A, that the religious society or religious order or diocese, synod, or district organization is a religious organization of a religious denomination, sect, or church. So the religious society is essentially a religious organization which incorporates, and yung religious organization, it should be already in existence. Letter B, that at least 2/3 of its membership has given written consent or has voted to incorporate at a duly convened meeting of the body. So hindi na to bago sa atin na dapat at least 2/3 ng members ng religious society has given na yung written consent nila to agree na they also want their religious organization or religious society to be a corporation. Letter C, that incorporation of the religious society or religious order is not forbidden by competent authority or by the Constitution, rules, regulations, or discipline of the religious denomination, sect, or church of which it forms part. So, ang isipin lang natin dito sa letter C is that the incorporation should not be forbidden by competent authority. Letter D, that the religious society or religious order desires to incorporate for the administration of its affairs, properties, and estate. So, dapat yung parang purpose nung religious society to be a corporation is for the administration ng affairs ng religious society, properties, and estate. Next is letter E, the place within the Philippines where the principal office of the corporation is to be established and located. So, dapat it should be within the Philippines lang where yung principal office ng corporation is to be established or located. And lastly, the names, nationalities, and residence addresses of the trustees to serve for the first year, it may be prescribed by the laws of the religious society or religious order. So, ang trustees, it should not be less than 5, but not less than 5 nor more than 15. So, under Section 114, it does not provide for a term of existence of religious societies if whether they are classified under corporation sole or corporation aggregate. So as such, the law intends that religious corporations may exist perpetually. Now let's proceed to Chapter 3 of Title 13, the one-person corporation. So, one-person corporations is hindi na bago sa atin kasi narinig na natin to sa ibang reporters or sa previous reporters. So, There are additions na lang siguro dito sa report ko. And one-person corporation is defined under Section 116, which is, it is a corporation with a single stockholder. But before that, let's read first yung Section 115, the applicability of provisions to one-person corporation. So the provisions of this Title 13, shall primarily apply to one-person corporations. Other provisions of this code apply suppletorily or as a remedy or supply to deficiencies, except as otherwise provided in Title 13. So balik tayo sa Section 116, as what I've said na one-person corporation is a corporation with a single stockholder, provided na natural person, trust, or an estate may form a one-person corporation. And despite of being a single stockholder, one-person corporation has a personality na distinct and separate from the single stockholder. And so sa first bullet, makikita natin na the incorporator of a one-person corporation being a natural person must be of legal age. So kailangan na if yung incorporator is a natural person, dapat it should be he or she must be of legal age. Second naman na bullet is as an incorporator, the trust. So yung trust na ginamit sa sinabi ko kanina na natural person, trust, and estate yung pwedeng mag-organize ng one-person corporation, yung trust on is, it doesn't refer sa trust entity itself. Pero yung trust na yon is the subject na minamanage nung trustee. The subject being managed by a trustee. So sino nga ba yung mga hindi allowed to form one-person corporation? So makikita natin that banks, quasi-banks, pre-need, trust, yun nga, trust entity, insurance, public and publicly listed companies, and non-chartered government-owned and controlled corporations, so they are not allowed to form one-person corporations. Makikita natin sa note na only a natural person, yun nga, trust, or an estate may form a one-person corporation. So, nasabi ko na yan kanina. So, in case nga na sa natural person, yung incorporator, he or she must be of legal age. So, the general rule under Section 116 is that a natural person, ulit, so a natural person who is licensed to exercise a profession may not organize as a one-person corporation for the purpose of exercising such profession unless otherwise provided under special laws. So, kahit na natural person ka man na of legal age, but you are licensed na mag-exercise ng profession, hindi ka pwedeng mag-organize ng one-person corporation. So if tatanungin, what if foreign natural person naman, pwede ba silang mag-put up ng kanilang one-person corporation? So ang question, ang sagot is that yes, foreign natural persons may put up one-person corporation, but it is subject to applicable capital requirement and constitutional and statutory restrictions in certain investment and activities. So, hindi lang sila basta-basta na pwedeng mag-put up ng one-person corporation nila. Kailangan rin na may test or they are subject to capital requirements, statutory restrictions. So, next is terms of existence ng one-person corporation. So, the term of existence ng one-person corporation shall be perpetual. it is continuing forever, or yun nga, perpetual, continuing forever, or for a very long time, gano'n. So, however, in case na yung trust or estate, however, in case ng trust or estate naman, yung term of existence niya shall be coterminous with the existence of the trust or estate. So, if yung one-person corporation is an estate or a trust, ang term of existence niya is yung term of existence din nung trust or estate. Yung original trust or estate. So next is section 117. But before that, for the information of everyone, some of the next sections are very self-explanatory and I will leave it to you as it is na lang kasi na-discuss naman na siya ng ibang reporters and what I will give you is if those things na na-discuss na nga ng ibang reporters is applicable nga ba sa one-person corporation. So, section 117 is the minimum capital stock is not required for one-person corporation. We have the general rule here that a one-person corporation shall not be required to have a minimum authorized capital stock. So this authorized capital stock, it refers sa number ng shares ng isang company na legally owned to issue or offer. So hindi na kailangan na may minimum authorized capital stock ang one-person corporation unless otherwise provided by special law. And also, unless otherwise required by applicable laws or regulations, walang portion ng authorized capital is required to be paid up at the time ng incorporation. Next is section 118, the articles of incorporation. A one-person corporation shall file articles of incorporation in accordance with the requirements under section 14 of this code. So, the one-person corporation is kailangang mag-file siya ng articles of incorporation in accordance sa requirements of section 14 of the revised Corporation Code of the Philippines. And the articles of incorporation is dapat naglalaman siya ng, nilalaman niya is yung primary purpose ng one-person corporation, principal office address, term of existence, names, and details ng single stockholder, yung nominee, and the alternate nominee, and yung authorized, subscribed, and paid-up capital is kailangang nakasaad din sa articles of incorporation. Letter A and letter B here are additional sa articles of incorporation na sinabi ko, which is under section 14. So, dapat hindi mawala itong dalawang to if magfa-file ng articles of incorporation ng one-person corporation. Let's proceed to letter A na if yung single stockholder is a trust or an estate, together with the name, nationality, and residence of the trustee, administrator, executor, or other person na nag-exercise ng fiduciary duties is dapat meron din yung proof of authority nung trustee and yung other person na nag-exercise ng fiduciary duties to act on behalf ng trust or estate. So, hindi dapat yun mawala yung proof together with the name, nationality ng single stockholder ng if it is a trust or an estate. Letter B is name, nationality, residence of the nominee and alternate nominee and the extent, coverage, and limitation of the authority. So, ang nominee and alternate nominee is hindi nasakop ng report ko, but I will give you a glimpse of it na lang kasi alternate nominee and nominee is sa susunod sa akin. Siya yung magdi-discuss nito ng in detailed. So, ang nominee and alternate nominee kasi is kailangan, required na i-designate ng single stockholder in case na mamatay yung single stockholder or maging incapacitate yung single stockholder. So, kailangan may written consent ng both nominee and alternate nominee na naka-attach sa Articles of Incorporation. Next is Section 119, Bylaws. So, sa one-person corporation, hindi required yung bylaws na i-submit and i-file. So, one-person corporation is not required to submit and file corporate bylaws. Only Articles of Incorporation is needed. Kasi nga yung bylaws is internal rules. So, ang i-govern lang naman nung single stockholder is yung sarili niya. So, hindi na kailangan nung internal rules na yon. So, bylaws is na-discuss na nung first reporters, nung ibang reporters. So, hindi ko na siya i-discuss. So, next is Section 120, Display of Corporate Name. A one-person corporation shall indicate the letters OPC either below or at the end of its corporate name. Yung single stockholder, he or she can use yung pangalan niya, provided na yung pangalan niya is accompanied with descriptive words aside from the suffix or the letters OPC. Yung single stockholder also can use other names provided also na yung ginamit niyang pangalan is may consent nung may-ari nung pangalan. And if deceased naman is yung estate nung deceased person. Also, dapat it is accompanied with descriptive words other than the suffix OPC. So example, yung pangalan ko, Desiree Gamboa, may descriptive word na estate, ganon. So yung OPC, pwedeng nasa dulo, sa end nung descriptive word. Desiree Ann Gamboa, estate, OPC, or yung OPC is nasa baba. Next is Section 121, Single Stockholder as Director, President. So, the single stockholder shall be the sole director and president of the one-person corporation. So, single nga, mag-isa niya. So, wala naman ng ibang magiging director and president ng one-person corporation, kundi yung single stockholder lang. Next is Section 122, Treasurer, Corporate Secretary, and other officers. So, within 15 days from the issuance ng Certificate of Incorporation, the one-person corporation dapat mag-appoint na siya ng kanyang treasurer, corporate secretary, and other officers na necessary sa corporation. And dapat i-notify nung one-person corporation yung commission within 5 days from the appointment of the officers. Next, under Section 122, ang single stockholder is not or may not be appointed as the corporate secretary. So, yung reason nito is makikita natin sa Section 123. A single stockholder is who is likewise the self-appointed treasurer. So, ang single stockholder, despite of not being or kahit na hindi siya pwedeng maging corporate secretary, pwede naman siyang maging treasurer. Pero if siya yung naging treasurer, dapat magbigay siya ng bond to the commission in such a sum as may be required. Pero if yung treasurer is not the single stockholder, so ibang tao yung magiging treasurer, hindi na kailangan na hindi na kailangan ng bond requirement. Also, if the stockholder or yung stockholder, yung treasurer, he or she shall undertake in writing to faithfully administer the one corporation's funds to be received as treasurer. And dapat yung funds is to be disbursed and invested according to the articles of incorporation na inapprove ng commission. And the bond shall be renewed every 2 years as often as may be required. So here it is, my last report under Chapter 3 of Title 13, One-Person Corporation, Section 123. So dito na nakapaloob kung bakit nga ba yung stockholder cannot be a corporate secretary. Section 123, Special Functions of the Corporate Secretary. So in addition to the functions na designate by the one-person corporation, yung corporate secretary kasi kaya hindi pwedeng maging kaya hindi pwedeng yung stockholder yung maging corporate secretary is that ang corporate secretary is the one responsible for maintaining the minutes book and yung records ng corporation. Another work of the corporate secretary is to notify yung nominee or alternate nominee of the death or incapacity ng single stockholder. Ang notice dapat is maibigay siya no later than 5 days from such occurrence. So, ang corporate secretary is siya yung nagno-notify ng mga nominee or alternate nominee if there is such occurrence na death or incapacity ng single stockholder. So, if yung single stockholder yung naging secretary, so wala nang magno-notify sa mga nominee or alternate nominee about his or her death or yung kanyang incapacity, state of incapacity. Letter C, another function ng corporate secretary is to notify the commission of the death of the single stockholder within 5 days from such occurrence and stating in such notice yung names, residence addresses, and contact details ng known legal heirs. So, kagaya nung sa letter B, siya rin yung magno-notify. Yung corporate secretary ang magno-notify sa commission about the death or about the death of the single stockholder within 5 days ng occurrence ng death ng single stockholder. And siya rin yung magbibigay nung names, residence, addresses, or contact details nung legal heir ng single stockholder. Letter D, the corporate secretary shall also call the nominee or alternate nominee and yung known legal heirs nung single stockholder to a meeting and advise the legal heirs with regard to sa election ng new director, amendment ng articles of incorporation, and other ancillary and or consequential matters. So, ang corporate secretary is ang dami niyang trabaho. Kailangan niyang mag-notify sa commission, mag-notify sa nominee and alternate nominee if there is death or incapacity na nangyari sa single stockholder. Isa rin siya sa responsible. Siya rin ang responsible sa minutes books. And lastly, kailangan siya rin yung mag-call sa nominee or alternate nominee and yung mga legal heirs kung sino, kung about, yung meeting is about sa election ng new director at saka yung amendment na rin ng articles of incorporation and other matters about the one person, about the corporation. So, these 4 slides, last 4 slides are the summary of the one-person corporation starting section 115 to 123. First is kung ano yung one-person corporation wherein it is a corporation with a single stockholder na ang pwede mag-organize lang is a natural person na dapat of legal age and trust or estate. If yung incorporator is trust, dapat if ang incorporator is trust, hindi siya yung trust entity but yung trust is yung subject na being managed by a trustee. Second, sa summary is, in case of trust or estate as incorporator, is there a need to submit proof of authority? So, yes, ang proof of authority to act on behalf of the trust or estate must be submitted at the time of incorporation. Who are not allowed to form OPC, one-person corporation, is also listed here. And if a natural person is licensed to exercise a profession, is not allowed to form an OPC. May a foreign national form an OPC? So yes, pwedeng mag-form ng one-person corporation ang foreign natural person, but subject siya to the applicable capital requirement, constitutional and statutory restrictions in certain investment areas or activities. So, ano nga ba yung term of existence of the OPC? Again, ang term ng existence of OPC shall be perpetual. However, sa case ng trust or estate, dapat coterminous siya sa existence din ng trust or estate original. What should the corporate name of an OPC include? So, ang included sa name ng OPC is yung suffix na OPC wherein it is indicated below or at the end of the corporate name. Is the OPC required to have a minimum authorized capital stock? So, kung nakinig tayo kanina, sinabi ko na to na no, hindi kailangan ng minimum authorized capital stock sa one-person corporation except provided by special law. Who serves as the director and officers of the OPC is the single stockholder. Siya lang yung pwedeng maging director and president ng OPC, and he can be the corporate treasurer or treasurer also, but not as the corporate secretary, who replaces the single stockholder in case of his death and or incapacity. So, if there's death or incapacity of the single stockholder, ang magre-replace sa kanya is yung designate niya na nominee or alternate nominee. And ang written consent ng nominee and alternate nominee na designated shall be attached sa application for incorporation. So what is the procedure concerning the appointment of officers to the OPC? Kailangan within 15 days from the issuance ng Certificate of Incorporation, the OPC shall appoint a treasurer, corporate secretary, and other officers na necessary sa corporation. Within 5 days also from the appointment of the officers, kailangan na ang one-person corporation is i-notify niya ang Securities and Exchange Commission using the appointment form as may be prescribed by the SEC. And lastly, is the OPC required to submit and file the bylaws together with the articles of incorporation? As what I've said, no, hindi kailangan ng bylaws na i-submit and i-file ng one-person corporation, but ang articles of incorporation is needed to be submitted and filed, which kailangan na ang articles of incorporation have the primary purpose, principal office address, and so on na nakalagay sa slide natin. Last naman is if the single stockholder assumes the position of the treasurer, is he required to post a surety bond? So, sinabi ko na yes, kailangan na if ang single stockholder is the treasurer, kailangan niya na mag-post ng surety bond And if kung another person naman ang treasurer ng one-person corporation is hindi na kailangan ng bond requirement. So that ends my report on sections 114 from religious societies to 115 one-person corporation to 123, section 123. The next reporter is Miss Karen Dulay.